Definitions. The definitions of words in this book are unique and only pertain to this book. It is suggested that one use a law dictionary for legal definitions of words used in this book. Agreement. Written terms and conditions between two or more parties stating specific performance each party must do to bind the other party to the agreement. There is no agreement without mutual consent. There can be no mutual consent if there was a concealment and one party did the opposite of what was expected. Material facts must be disclosed. Authorization must be granted. Permission must be obtained. And adequate consideration, open brackets, money, must be given to have an agreement. Example, in the agreement, who was to provide the funds to issue the bank loan check? Was it the borrower or the bank? Was the bank to loan you legal tender as consideration loan to obtain the promissory note? Or was the bank to loan you the opposite of legal tender? The cost and risk of the agreement changes significantly depending on the answers. Asset. Anything owned that can be sold. A car, house, legal tender, promissory note, securities, and bonds can be sold. So they are assets to the one who owns them. Banks record legal tender as a bank asset. Banks also record owing legal tender as a bank liability. Bank agent. Anyone who benefits from the current banking system and or is responsible for enforcing the banking system. Bank employees, police, attorneys, media, judges, lawmakers, and anyone aiding and abetting the trustees, Congress or representatives of the bankruptcy of the United States, anyone depending or benefiting from favors of bank money, either directly or indirectly, or loans to be in business, a foreign agent or unregistered foreign agent representing a foreign interest such as judges, police, and attorneys, as in United States Code, Title 22, Section 610 to 615, or in any court case making them foreign agents or any other law. Bank. Control media and publishing companies. Any media or publishing company that is biased in favor of the current banking operation or refuses to give equal time and representation to exposing the whole truth as outlined in this book. Media which has bank debt and is dependent on the bank to renew the loan or where the bank may withdraw the loan. Media which is dependent on advertising dollars whereby a bank can ask borrowers not to advertise with such media that expose the whole truth and nothing but the truth concerning the alleged bank loans. A bond. A bond is a promissory note, an IOU agreeing to repay the principal plus interest. Check. The Federal Reserve Board defines a check as a draft or order upon a bank or banking house purporting to be drawn upon a deposit of funds for the payment at all events of a certain sum of money to a certain person therein named, or to him or his order, or to bearer, and payable instantly on demand. Definition as per Black's Law Dictionary. Please do not forget that the bank claims a bank liability is a debt. To make a checking account balance into money, equal protection must be denied and money must be redefined to mean the opposite. Let me read that again. To make a checking account balance into money, equal protection must be denied and money must be redefined to mean the opposite. Or the promissory note is money or check knitting. It appears that bank may lead people to believe it is check knitting if one writes a check without first having a checkings account balance asset to match the amount of the check. The checking account balance has no value without legal tender recorded as a bank asset offsetting the liability. The check merely transfers a bank liability checking account balance from one checking account to another. A check is not money. A check acts like money because you can exchange it for cash. Consideration. The reason for entering into the agreement. Consideration must be something of value, such as an asset or legal tender, cash. A check written without first depositing an asset, money, so that the check can be cashed is illegal consideration. If the check was the funds loaned to obtain the promissory note, then the promissory note cannot be used to fund the check. If the promissory note were used to fund the check, then the check cannot be the consideration loan to obtain the promissory note because the bank owned the promissory note before the check paid for it. Either the promissory note had to be loaned to the bank or the bank stole the promissory note to fund the check. Stealing the promissory note means that no valuable consideration was given to obtain the promissory note. Counterfeit or counterfeiter. To forge, to alter or change a document after it was signed without knowledge or permission or authorization of all parties signing the document. An intent to deceive by passing the forged document as a genuine one that was not altered. Example, after the promissory note was signed, the bank stamps the back of the instrument, thus allowing the bank to use the promissory note to fund the check. The bank created money. Counterfeit money. For purposes of this book, this means money banks created or caused to be created and loaned at interest. It does not necessarily mean the banks committed a crime. Credit. The postponement of payment of money. I'll read that again. Credit. The postponement of the payment of money. The postponement of the payment of money cannot be transferred by check if a check must have a sum certain of money to make it valid. Is the promissory note money or credit? The definition of a promissory note means the promissory note must be paid in money. How can it be money and mean money is owed at the same time unless there is more than one kind of money, legal and non-legal tender at the same time? Damage. In court, you cannot win damage awards without showing you were damaged. One has a damage if one is the victim of a theft. The bank believes they were damaged if you do not repay the loan. Likewise, you were damaged if the bank did not loan you other depositors' money, or if the bank refused to repay the loan from you to the bank. Deposit. Money or negotiable instruments, checks, or commercial paper, promissory notes, handed to a bank. The bank credits a checking account, demand deposit account, savings account, or certificate of deposit, creating a bank liability. The depositor loaned the bank money or funds, allowing the depositor to withdraw the money deposited or loaned to the bank. Equal protection. Bankers and non-bankers having the same rights. Bankers cannot create money or credit and loan it out to non-bankers. Exchange. Trading value for value. The barter or swap. Example, you give the bank something of value worth 100 and they swap it for something of value worth 100, giving you back 100. A 100 loan is where one party hands 100 to another party to be repaid at a later date. Stealing 100 from one party and returning the 100 back to the victim is not a loan. The stolen 100 does not legally belong to the thief. It belongs to the victim. An exchange is not a loan. Chicago Federal Reserve Bank publication Modern Money Mechanics, page 6, claims the bank exchanged the promissory note for credit in the borrower's transaction account and called it a loan. The bank simply redefined the word exchange and called it a loan. The borrower hands the lender 100 and the lender hands the 100 back to the borrower, claiming the lender loaned the borrower 100. For this exchange, the borrower must pay a fee as if there was a loan. The borrower lost 100, the lender gained 100. And for this privilege, the borrower must repay the 100 plus interest. Forgery. Counterfeit. Most people think it means your signature was signed by another person. However, a forgery includes changing a document after it was signed. When the document was signed and then altered, your signature becomes null and void. Fraud. Intentionally perverting the truth for the purpose of inducing others to rely on a lie or misinformation. False statements or half-truths and half-lies, with the other party relying on such information to enter into an agreement in order to have the party part with something of value, such as a legal right or property. Knowing one will breach the agreement before entering into the agreement. Example, the bank claims they will make you a loan. The bank conceals that there is a loan from you to the bank exchanged for a loan from the bank back to you. It was concealed. The bank never loaned you 1 cent of legal tender that existed before you signed the agreement to be loaned as consideration to obtain your promissory note. The bank called an exchange a loan and never repaid the loan from you to the bank. The bank received your property for free instead of loaning you legal tender to obtain your promissory note, thus changing the cost and the risk without the borrower being aware. The bank's omission, concealment, false statement, and breach of agreement changed the cost and risk. If people understood, they would have voted out every lawmaker, judge, and police official aiding and abetting such a practice. This is why the bank hides the truth. Fraudulent concealment. The hiding and/or suppression of facts which would significantly change the cost or risk of an alleged agreement. To mislead the borrower as to which party supplied the capital to fund the bank loan check. In or out of court, misleading or hindering the acquisition of information, disclosing a right or transaction in an alleged contract or agreement. Planning to escape investigation, suppressing the truth, or preventing inquiry to the truth. Interest. The charge for the use of borrowed money, not the opposite of money, or the postponement of the payment of money. So interest. The charge for the use of borrowed money, not the opposite of money, or the postponement of the payment of money. Lastly, to steal. Theft by gaining possession of another party's property by using a trick, fraud, or policy or device designed to convert the property into another party's possession, and having the economic effect of a theft. Depositing a promissory note instead of loaning legal tender to obtain ownership of the promissory note. Placing an illegal lien on property without fulfilling the agreement. Originating or reinforcing a false impression and not correcting the false impression or preventing one from obtaining the truth as to the correct information regarding the real cost and risk of the transaction in the alleged agreement, which might change the judgment of a party entering into the agreement. Example, was it an exchange and then charged as if there was a loan, or was there a loan? Who provided the capital to fund the check? Exactly who was to loan exactly what to whom? Liability. A bank liability means the bank owes a depositor legal tender cash. A liability is a debt. IOU, checking account, balance, demand deposit account, savings account, certificate of deposit, or check. An unpaid obligation. A scorecard of how much legal tender or cash the bank owes depositors. A promise to pay. A liability is something you owe. A promissory note is owing money. A liability is a legally enforceable claim on the assets of a bank. Transferring a liability by check from one checking account to another checking account is not payment of a liability. The liability remains on the bank books. Payment of a liability is proven when the liability no longer remains on the member bank's balance sheets. A bank liability is recorded in the accounting books on the far right-hand column of numbers. Lien. The right to someone's property or assets as a result of money they owe or are in default of paying. The bank receives the lien on your house if you take out a loan. If you do not repay the loan, the lien on the house allows the lender to foreclose and obtain the house. Loan. Money or asset advanced or delivered to another party to be repaid at a later date with or without interest. The agreement can be expressed or implied. Example, if a bank receives a promissory note from a borrower and records the promissory note as a loan from the borrower to the bank assets and liabilities increase by the amount of the loan to the bank. When a bank claims it granted a loan, the bank's assets and liabilities increase by the amount of the promissory note. It is the same situation if the bank received the promissory note in a fraudulent conversion and loaned the value of the stolen property back to the victim. The question is, did the bank hide this transaction? Did the borrower give the bank permission? Did the borrower have knowledge? If there was no knowledge, how can there be mutual understanding or an agreement? Was it a loan, theft, or did the borrower have knowledge? According to the accounting records, it is either a loan to the bank or it is a theft. According to the accounting records, at a minimum, it is an implied loan to the bank because the bank recorded it as such. You have a right to receive the loan back in its equivalent in kind, meaning you have the right to receive the principal and interest paid to the bank. If it was stolen, most people would want their stolen property back. Misleading, delusive, to misrepresent, to deceive, and to lead astray. Money. As defined in this book, money must be a bank asset. In this book, the Federal Reserve Bank defines money as a bank liability. This book believes a bank liability is not money. For illustrative purposes, in this book, the word money can be used as the bank's definition of money being a bank liability. The point of the book is to show money legal tender is recorded as a bank asset. Owing legal tender is a bank liability. If owing money is money, then it is the opposite of legal tender. The bank deals in legal tender and the opposite of legal tender, checkbook money, and call both money. Treasury notes, not Federal Reserve notes, are called United States notes. Promissory fraud. When the bank claimed they would loan you a bank check payable in cash, and when the bank policy showed intent to breach the agreement and use the promissory note to fund the same check that was to be the loan consideration for the promissory note, it was a misrepresentation of the lender's agreement and advertising. Promissory note. A promise to return money loaned to a borrower with or without interest. An unconditional promise to pay a sum certain in money. Please note, it does not say the opposite of money or credit, which is the postponement of the payment of money. Stolen, theft. Receiving something for free when you agreed to loan something of value. A plan to deny another party equal possession under the law. Money, credit, or agreement to obtain something for nothing. A dishonest act or wrongdoing to willfully retain control of another party's property without authorization or beyond authorization and permission given, with intent to deprive the party of their property. For purposes of this book, stolen or theft means the bank obtained the promissory note or credit card agreement without earning the money to loan, like non-bankers earn money, and or without loaning 1 cent of other depositors' money, and by creating money or bank liabilities to obtain the bank loan agreement, promissory note, or credit card agreement. Example: the bank records the promissory note on the bank's assets and increases the bank's liabilities. The bank obtained the promissory note for free simply by increasing the bank's debt and not paying the debt and making it appear that the bank paid for the promissory note by transferring the debt to another person by means of a check. The banks could obtain the liens on the nation's assets and national debt simply by increasing the bank's debt and not paying them. To steal. Theft or thief. Obtaining the promissory note without the banking loan. Let me read that again. Obtaining the promissory note without the bank loaning other depositors money and by creating money having the economic effect of counterfeiting. Obtaining the promissory note by increasing the bank liabilities. To steal. United States notes. This book refers to silver certificates, greenbacks, and paper money issued interest-free by the government, as United States notes. A note is an obligation. By being a United States note, it shows whose obligation it is to pay. Generally speaking, it is obvious that a United States note is cash and is not paid but merely circulated as money or redeemed for silver or gold. For purposes of this book, we are only looking at the general economic effect, not long-winded legal arguments on exact theories of paper money or gold and silver coins. Wealth. Property assets, which has value and can be sold. Wealth includes your labor because labor is exchanged for goods and services. People barter wealth for other people's wealth. For example, 10 chickens exchanged for 1 pig. Today, money is used to help facilitate exchanging wealth. These terms are designed to illustrate the economic effect of the bank loan agreement using everyday language. The author is not claiming the bankers are criminals. You are the judge and jury, and you decide whether there is a fraud and whether we should vote to cancel your bank loans. All right. I'll stop there for now. I want you guys to soak that up. It seems like a very interesting book. Very, very interesting. Soak up that information. So we'll read this book in a series. So I'll stop there for today. So we're starting at high school pop quiz. I thank you for your time and patience.